Any mention?
May I please, Your Lordship, so item number 15.
Yes. Oh, yes.
This case may be referred to other.
Yes, yes. 15 disabled listed before any other bench. This number 16 also. Who is there in number 16?
Petition. Same matter. Same matter.
That there also I will have. Number 16 also same order.
My lord, I beg to mention item number 12 from the hearing list, my lord. 12 from the hearing list. This is Balpakram acquisition matter, my lord. My lord, may kindly take up after a week or two, my lord. Some documents that were supposed to come, I have got a copy of those. I'm just in the morning they have given me.
Relevant for the purpose of deciding.
My lord, there was an order to produce those.
No objection. Objection. Item number 12. That's straightforward by Mr. Given. Learned counsel for the petitioner. List this matter after 2 weeks.
2 weeks, my lord. Obliged.
May I please, Your Lordship? I beg to mention item number 5.
Yes.
Lordship, I'm praying that this matter may come after 2 weeks.
This 2017 matter.
Lordship, today the senior conducting counsel is out of station.
Pertaining to LA case.
LA matter.
How much? Garo Hills.
Garo Hills.
That's straightforward by Lord counsel for the petitioner. List this matter after 2 weeks.
2 weeks.
Your badge.
May I please, Your Lordship? Your Lordship, I beg to mention item number 13, Your Lordship. I have taken the concern of the other party.
13.
May it come after, yes, Your Lordship. May it come after 2 weeks, Your Lordship.
You are for the petitioner.
Yes, Your Lordship.
When do you want it?
After 2 weeks, Your Lordship.
No objection.
No objection.
Means the same thing as per by Lord counsel for the petitioner.
Hand Your Lordship.
Lordship, I beg to mention item number 6.
6. Again 2017 matter. Yes.
Lordship, I pray for some accommodation, Lordship.
You are for the respondent.
Lordship.
I'm for the petitioner, my lord.
What is that matter about?
My lord, this is related to service, my lord.
You don't follow?
Related to service, my lord.
Related to service also.
My lord, here what had happened, my lord, petitioner had applied for a post in the CRPF. My lord. That was in pursuant to the advertisement dated 2015. So, my lord, thereafter, in the first round, my lord, after
selection, appointment and selection.
Yes,
Okay.
my lord, appointment is.
Relating to appointment and selection.
Yes, my lord.
So he is not in service.
He's not in service.
You'll be praying on behalf of Mr. Muzika.
Lordship.
Yes, Miss. Pardon. Appearing for the respondents. Praise that. Mr. Dr. Mujika, the learned DSG, appearing in this matter is disposed.
2 weeks, Lordship.
She prays that matter may be indisposed and prays that matter may be urgent for 2 weeks. Learned counsel for the petitioner has no objection. List after 2 weeks.
Lordship, I have a similar prayer for item number 4.
4 also you were. Item number 4 is a very old matter, isn't it?
Lordship.
This is an. Who is for the petitioner?
I am for the state respondent, my lord. Petitioner is capable.
Yes, ready to do item number 4.
Lordship, senior counsel is here. He's ready to take up the matter, Lordship, but if they're praying for time, Lordship.
So he will accommodate them. He's ready to accommodate him, isn't it?
Lordship.
Very nice strategy. Yeah, this same order with regard to Dr. Mojike. Only the here also is respondent, isn't it?
Lordship.
Same order will do. 2 weeks.
2 weeks, Lordship.
Highly obliged,
Highly
Lordship.
obliged, Lordship.
May I please, Your Lordship? Lordship, I beg to mention item number 17, Lordship, on behalf of P. Riatam, the counsel for the petitioner, Lordship.
17.
Lordship.
The last item.
Lordship.
Yes.
After 2 weeks, Lordship.
May it please your lordship, only they need to correct something, your lordship, as per the order dated 17/5/2023. Because there is
that has not been done.
a lordship, because in my copy there was no correction as such. They have not served the corrected copy
They
also.
may be granted, Lordship.
No, but then if there is some order exists with regard to correction of certain things, that has to be carried.
Lordship.
You see, like, for that you cannot take adjournment, isn't it?
Lordship.
That has not been done. What is that? What is that correction?
Lordship, what happened in the body of the petition, instead of East Khasil, the district has been referred as East and West Khasil district. East and West. Then the date of birth of the child has been shown as 3/11/2023. Lordship.
Whether that has been reflected in the last order.
Lordship, kindly see the order dated 17/5.
Last day.
17/5.
There's nothing, no such order. It's only after 3 weeks.
17/5, your lordship. That is the order 17/5. Order.
There seems to be many orders.
Lordship will find it in the index. East and West Khasils instead of East Khasil. That is then Lordship kindly come to paragraph 12 of the petition. The date of birth has been shown as 13/11/2023, where instead of 13/11/2022. I think that has not been corrected even in the court copy
Lordship,
also.
the conducting counsel here, she's unwell, Lordship.
That is okay, but then this order is passed. See, this is order of May. At least
Then, Lordship, it will be corrected.
that will be corrected, but then cannot remain pending for so long. If there is a mistake, it should be corrected immediately.
Inform, Lordship.
Prayer of adjournment stands at a different footing.
Lordship.
You are not in this matter. You are not appearing in this matter. Write her name. Your name, you give me. Appearing on behalf of
P. Riatam.
Ilaitham, Learned Counsel for the petitioner. Submits that. She's unwell.
Lordship.
Submits that the counsel or the petitioner is not well and not in a position to conduct the case today. She prays that the matter may be adjourned for 2 weeks. Mr. N.D. Chulai, Learned AG, appearing for the respondents, points out that certain errors in the petition, which are reflected in the order dated 75/2023, passed by this court, has not been corrected till date. The petitioner is directed to correct the same forthwith. Prayer for adjournment allowed? No.
Yes.
List it after 2 weeks.
Only I appear for 1, 2, and 3, Your Lordship, because there are private respondent 4 and 5.
Just correct it.
Lordship, similar prayer for item number 7, Lordship.
Apply, Your Lordship.
Same counsel.
Lordship.
Then nothing will remain.
For respondent number 1, 2, and 3, Lordship.
Item number 7.
Lordship.
This is also old matter. These are all 2018 matter. You are making mention on behalf of P. Raitham.
Lordship.
Yes, petitioner.
Lordship, no objection.
Record her name on behalf of appearing on behalf of such and such learned counsel. Mr. So and so advocate appearing on behalf of the so and so appearing for the respondents. Please that conducting counsel is not well. Submits that conduct counsel not well and prays for grant of adjournment for 2 weeks.
I'm appearing on behalf of respondent number 4.
Prayer allowed. The prayer has not been opposed by the petitioner. Prayer allowed. List it after 2 weeks.
Highly obliged.
List the matter after 2 weeks. Yes.
May I please, Your Lordship, item number 8.
So this was it the same last item remaining in the hearing list? So everything is gone, exhausted. The entire list is exhausted.
8, 9.
8 and 10.
Very difficult this way. Yes, Mr. Sulai. You are
Lordship,
appearing
in
for
item 8, since they are seeking for adjournment in item 8, Lordship, after going through the file, it appears, Your Lordship, that the order which has been impugned by the petitioner is not annexed in the writ petition.
Yes, Mr. Sheikh.
Because it has been adjourned so many times, so
It's 2018 matter,
Yes, Lordship.
and the court is proceeding without the impugned matter.
after reading the file this morning, then I could detect 8-3. I don't see, Your Lordship, that.
Shall we wait for some time? Let the matter be called.
Lordship is there, Lordship, because here my
We'll do one thing. You just mention after some time. Let the matter be called. You'll be there. We'll see the record from here. Okay? Make your prayer when the matter is called. Yes.
Main list, item number 1.
May it please, Your Lordship. Your Lordship, I'm entering appearance for respondent number 2.
He's a petitioner. On the last
Speak it
occasion,
more.
petitioner was not there.
Lordship, he's on sanctioned leave.
Somebody should be there to mention. So we will just record your appearance
Your Lordship.
and we'll fix a date again since he's on sanction leave. Otherwise, we would have dismissed the matter. See, because on the last occasion also nobody appeared for the petitioner. None appeared for the petitioner when the matter was called for. Stop. On the previous occasion also, petitioner was found to be absent. It has been pointed out by, give me your name,
Mr. Shyam. S. Shyam.
that the counsel for the petitioner is on leave. Give a full stop. Right, Miss So and so enters appearance for
Respondent number 2, Your Lordship.
respondent number 2. After for interest of justice, this matter is adjourned and listed after 2 weeks.
Item number 2,
Not together, we will not say together, just after 2 weeks.
It's not there, no? You have not annexed it.
So far as the resolution, Lordship,
What is impugned here, Mr. Sheikh?
I have impugned that resolution.
Dated? What is at what page you have encased it? Enclosed it?
Can you come to page 9, Lordship?
9, Lordship.
Page 9.
Yes,
Lordship,
Lordship.
yes.
That prayer.
Of the writ petition.
Yes.
That is the relief claim in the writ petition.
Impugned resolution number 3 of
Margin Committee
8
resolution number
2015.
3 dated 8/3/2015. So it is not there.
That part, Lordship, on the objection raised by my senior Lordship. So I have relinquished that. There must be an order. I am not equitable. I'll try to get the order, Lordship. My senior has already raised that objection long back. So accordingly, I have relinquished that part, Lordship.
So where it has been recorded? In which order?
So, Lordship, right now I'm not.
You should
I'll, on the next day I'll apprise the Lordship.
So today there will be. Who was praying for adjournment? Yes. Mr. Shula, you will just wait for these things. He pointed out on the next day.
Yes.
If he says that he has relinquished his right, it must be reflected somewhere.
No, what happened, Your Lordship? Because the order of appointment.
This is a resolution because I am challenging the approval.
If he relinquished that, then the writ petition fail, Your Lordship. It's up to him, Your Lordship. It's up to him, Your Lordship. It's up to him, Your
I am
Lordship.
challenging the approval, Lordship. Resolution on its own, nothing unless it is approved. I am challenging the very approval.
We'll see whether you can challenge it legally or not, minus challenge to the main resolution. We'll
It's
see
up to him, Your Lordship. It's up. He is the master of the proceeding.
Yes. You are appearing for 5 and 6, the managing committee. Yes, Mr. Qureshi is there.
Yes, yes,
Yes,
5 and 6. Yeah.
5 and 6. So you are seeking adjournment?
I thought to take instruction, but after hearing the Mr. Sheikh,
No, see, this initially
My Lord.
there is a prayer for adjournment, madam. Okay. So whether you still stand with that prayer or not, otherwise we will proceed. What Mr. Sheikh said, we can find it out from your records.
Yesterday,
If
Lordship.
you are ready, then we can
in
proceed.
the morning we have asked for time to take some instruction from the client. So that case matter may be taken up after 2 weeks.
So that is what. You are not supposed to change your submission on the basis of the development which takes place. They shift the burden to them.
He is shifting the burden on me.
So any objection to the prayer?
No, Lordship. Yesterday, senior personally asked me that we will ask for time.
No, that is all right. I see.
That now today he is taking the different stand. That is
I'm
what.
taking different step. I'm same step. I'm taking.
A prayer has been made on behalf of Resolution number 5 and 6 by Mr. M.S. Qureshi, Learned Counsel, on the ground that some more instructions are required to be obtained in this matter before the matter proceeds for hearing.
Then also same.
Yes.
The prayer has not been objected by the Learned Counsels. Learned Counsel was the petitioner. Prayer allowed. List this matter after 2 weeks. Mr. Qureshi, these are quite old matters. We should be
Then
dispose it of.
if this item is adjourned, Your Lordship, then 9, 10 will have to be adjourned.
These are all
That's
connected.
on the same issue, Your Lordship.
That means there will be no work left for this court now. After 9, 10, is there any other matter? No. So 9, 10 also same order will.
No.
You are also there.
Only simply adjourn, Your Lordship, because related. This is the case.
Is there any order to tag those matters together with this?
Your Lordship, in fact, it
The
was
only
on
one
my
issue involved in this case regarding the appointment of the Hindi teacher.
Hindi teacher.
There
Whether
is
there
no
is a,
Hindi teacher post is available to the government. That is the only issue here.
that is the only issue, Your Lordship.
So next 9 and 10, just say after 2 weeks.
Just
Both
simply
are-
adjourn, Your Lordship. Simply adjourn.
on the prayer made by parties. On the prayer made by the parties, this matter after 2 weeks, 9 and 10.
Apply, Your Lordship.
Item number 11,
Your Lordship, in this matter, I am for the petitioner.
Yes.
In this case, Your Lordship, last question I state that the report submitted by the state respondent is not the report which is inquiry took place. So I sought for this inquiry report, but it is not there. So I apply for under RTI. So it is under process, Your Lordship. I may be given some time so that I can produce this one.
What report? Report of
Your Lordship, in this case.
There is an inquiry which has been conducted by the government. There are two teachers who are claiming the same post, and I am for this managing committee. My situation is very tight. Both of them, they are claiming the salary. So we say that our stand is before this honorable court is this: whoever succeed in the writ, my lord, we will pay the salary to them. But in between, my lord, what happened?
Whom you are supported? You must be supporting one of the teachers. You cannot support
two
teachers.
They are both. They are claiming, my lord.
That is okay.
They
can claim.
Yes.
Provided their claim has certain legitimacy, so far as you are concerned. It's like you have to say.
Our stand, the prayer which has been made against of us, is very limited. Our stand is this: whoever succeed in the writ, my lord, will pay the salary, because they claim and counterclaim of salary, my lord. It's not about who is teaching or who is appointed legally or illegally.
But then salary is.
It is the government. It is the government who has to take a stand. Who has been appointed legally?
This is an aided school.
Aided school.
So aided school, normally government appoints the teacher who is recommended by the managing committee.
Yes, and there lies the claim and counterclaim. One is saying that.
So you are the managing committee.
Yes.
Whom you recommended. That is what. Is it not your duty to place it?
We have placed the record, your lordship.
What the record says.
Our stand is only very limited, because the prayer which has been made is that about the salary. About the salary, what is fallen from my lord is also very pertinent. But
no. See, I am trying to understand. Nothing has been fallen. My things are. These are only queries. Okay, because I do not acquainted with the facts of the case. I am here to go through these things. Now, so far as your submission is concerned, what I could get is that there are two teachers claiming for salary. So, claiming salary in relation to one post.
Yes.
See, the normal thing is that what we understand that two teachers cannot hold one post.
Yes.
There must be one teacher.
Yes.
Now, who is holding it? It is the managing committee.
Normally, a Hindi teacher is not a sanctioned post. That is our stand.
So if it is not a sanctioned post, that means the appointment is by the managing committee.
Yes.
So state has no role there. The state is not paying salary if it is not a sanctioned post.
Yes.
So then you will have more burden here. The burden comes to you.
No, burden lies on us. But the fact is this: when the government is giving salary to Mr. A or Mr. B, Mr. A and Mr. B, both of them, they are claiming for the same post.
It is a non-sanctioned post. So where is the question of government paying the salary? Yes, Mr. Abraham.
Yes,
what is your stand? It is not a sanctioned post.
It's like the post. The petitioner has written an application to our department to clarify the position of the petitioner. In that case, we have given the detailed report. It is not an inquiry report, but the detailed report with regard to the clarification sought by the petitioner. We have a report, but there's no inquiry report. It is just a report with regard to the position of the petitioner.
They have not referred to some inquiry.
I apply under RTI, and this is the reply you will see. Just I am giving. This
2019 case, you are applying for RTI 9 now.
Because after the records is available, the records will speak. Government affidavit as far as
now Mr. Devnath is asking for time on the ground that certain documents will be there.
And after this inquiry, Your Lordship, I am getting my salary. Government is released my salary.
So you are getting your salary now.
Yes.
So matter has become infructuous then.
So Your Lordship, in this matter, only this area of salary, I am asking for the area of salary.
Order passed by this honorable court,
So,
which I have approached lordship. There is
so
an
Lordship,
order, lordship, that is in my counter.
I may be allowed to put this inquiry report. I will be getting soon. Because government is denying for having the inquiry report, and in this letter, Your Lordship, it is specified the inquiry is there.
You are claiming salary, and who else is claiming salary?
Myself, lordship.
Your Lordship, in my case,
Lordship.
You are the private respondent. You are private respondent. You filed your affidavit.
Yes.
Your Lordship, in this case, I have only came for the non-release of my salary in this case, and after this private respondent, he entered in my case. So I am not having any grievance against this private
It's all
respondent.
right. But then says like, if your claim.
So after that, Your Lordship, when during the pendency of this writ petition, then government has conducted the inquiry. So then after this inquiry conducted, then they released my current salary. Even
Mr. Abraham says there is no inquiry. There is only a detailed report.
So, Your Lordship, I will be producing this one inquiry report.
Is there any
because
inquiry?
in this letter it is clear, Your Lordship.
No, that is okay. You have applied for something. That is not clear. That shows that you have applied for something. The reply may come that there exists nothing.
My lord, government affidavit as well.
Let me
No, the confusion is because of the two order of this honorable court. My lord, if my lord come to the order dated 30th 11/2018, writ petition number 459 of 2018 is in the affidavit that I have filed.
In the application number 459.
Yeah, but in my affidavit
459 is connected with this case.
Yes, Lord.
Yes.
These are listed together. It's listed together.
Yes. In my affidavit, if my lord kindly come to.
This 459 is a disposed of case.
Yes, disposed of case. And this matter was disposed.
Here also issue was same salary, no?
Yes.
Something.
What happened? Both of them, they have approached this honorable court, and the honorable court passed an order on the motion stage directing the managing committee to release the salary.
30/11/2018.
30/11/2018. If my lord may kindly come to para 5.
Yes.
In view of the stated position, nothing survived for determination in this petition. Suffice is to say that the managing committee of the school management shall ensure payment of salary to the petitioner which effect from so and so till ending August 2018. Within 10 days thereafter on release of the fund by the central government and sanctioned thereafter by the respondent to pay the salary to the petitioner regularly after adhering to the rules. So this is one order. One of the petitioner approached this honorable court. This was the order.
This is
his order.
Mr. Sheikh.
Now, yes. Now, my lord, may kindly come to next page.
Next page.
Next page. That is order of writ petition number 56 of 2019.
Okay, you are referring to your affidavit?
Yes, my affidavit.
Your affidavit is not here, I think. Affidavit in this case, in 56.
In my affidavit is on page 50. Writ petition number 56.
56.
56.
1 minute. No index. Wait, what is this? Yes, your affidavit is?
Respondent number 8 and 9.
Filed on 23/7.
Yes. Page 12, if I have not got it.
Page 12.
Page 12.
Page 12 is.
Sorry, my lord, we kindly come the page. There is some problem with the page. There's 2 number written. So, if my lord may kindly come to the last page.
Last annexure of your
last
affidavit.
annexure. This is an order passed by this honorable court on WPC number 56 of 2019.
No, last is something.
Order dated 5/3/2019.
No, last is something else.
Not this. Last page is 18. This is another annexure.
if my lord may kindly see the order sheet.
Wait, he is referring, but it is in this
Rejoinder. Rejoinder.
Rejoinder.
Yes, it is in the rejoinder of the writ petitioner is there, my lord. My lord may kindly refer to the rejoinder. Or if my lord may kindly see the order sheet.
You refer to one page at a time, sir. Wait. Rejoinder in which page? Rejoinder by? No, this is an affirmative opposition file.
My lord, it will be proper for me to say that my lord may kindly see the order sheet, my lord, of writ petition number 56 of 2019.
Order dated?
Order dated 5/3/2019.
5/3?
Yes, my lord. 5th March 2019. Probably it will be the first order in the writ petition.
Yes.
My lord, may kindly see, heard Mr.
Yes, Devnath.
R. Devnath, learned counsel for the petitioner who submitted the petitioner is not getting her salary since September 2018. My lord, may kindly see the last paragraph, second last paragraph. Learned counsel for the petitioner also submitted the government has released the salary of the petitioner, but the managing committee is not depositing the salary in his account. If it is so, the managing committee is directed to release the salary immediately to the petitioner. We are in a tight situation, my lord, where both they have directed the managing committee to release the salary.
No.
Now we are getting the salary for one person.
Why should you be in tight situation?
My lord, may kindly see.
See, this is you have not been directed here. You see, it says if it is so.
Yes.
That means the correctness of the submission is to be determined by you. This is only court had acted on the submission made by the party.
Petition.
There is no doubt so.
But on this matter,
this what is the implication of this word if it is so? That means it may not be correct.
No. What we have determined is that the court was saying, our interpretation was this: if the government has released the money to the managing committee, now it is for the managing committee to give it to the petitioner. That was our interpretation, your lordship.
If it is relief, if it
Yes.
is so,
because they are saying, but the managing committee is not depositing the salary in his account. If it is so, the managing committee is directed to release the salary immediately to the petitioner.
Yes, provided if it is so.
Yes,
Now
because the money was released to us.
That is okay. Money is released.
Yes.
But then it is released for the teacher who is working there.
No,
not for Mr. Devnath or Mr. Sheikh.
No, what has happened, your lordship? One is the Hindi teacher, and one is the regular teacher. Now they are saying that even Hindi teachers are also sanctioned teacher.
If
And
they
for
say
once,
that will not do. See, whether this is sanctioned or not, this
because,
will be
because the
proved by-
matter is pending. Because the matter, our stand is this: because the matter is still pending. The money is lying with the bank.
See,
and subsequently, what happened, my lord? The money is released directly into the account. Managing committee has no role because subsequently there is an order of the government where the money goes directly into the account of the teacher. So we to determine at this point is very difficult.
Now, if it goes directly to the teacher, you are having no role. So far
Yes,
as
we are having no
disbursement
roles.
of salary is concerned.
Yes.
Okay. No, but then see, I do not know. I don't think that none of you have made a definite set of submission. You see, like this is what I believe is that you are referring to order dated 5/2019, when it has been reflected that if the managing committee has received the salary and if they are not releasing, they should do it. Now here you do not say that the managing committee is not receiving salary. Salary is going to the account of the teacher.
No, because this order was not passed after hearing the managing committee.
So okay, you could have sought modification of these nothing. So
Your
long
Lordship-
you do not seek it.
My lord, for that we have to go to the history of the case, lordship, when the school was taken over by the management, when the school was taken. So
Now,
and
if I
government
can submit, your lordship, now since the inquiry, so-called inquiry or a finding of the government is there, the matter can be heard. RTI reply is not required even.
Now the thing is that the post for which the petitioner is claiming salary, whether that post is a Hindi teacher's post or it is some other assistant teacher or something, what?
That is what, your lordship,
go by
because
the records.
by the records it will be determined. And there
No, no,
is
if a
already-
person, just you being a managing committee, you do not know who is serving in your school.
No, because we know who is serving, but here
Who is serving there as a Hindi teacher in your school?
petitioner. This is the stand of the managing committee.
Petitioner, if he is Hindi teacher, it means a non-sanctioned post.
Yes.
Will not get salary from the government.
Yes.
It is for a managing committee.
Yes.
Now, what about Mr. Sheikh? He is serving in what capacity? Is he serving in your school?
He is an assistant teacher. Your
So
Lordship.
he is also serving in your
He is
school.
also
And his salary is paid by the government.
Yes.
So it means the claim of Mr. Devnath government is not
incorrect.
Incorrect so far as the claim with regard to the payment
Of salary. Payment of salary.
sanctioned salary.
Sanctioned salary.
But then if he is working, now you say he is working as a Hindi teacher.
Yes.
So definitely he is entitled to some salary.
Yes.
That is what you should pay him. You are not paying that.
No. What is the practice? What is going on in the plain belt? If there is a 3 sanctioned teacher in the school, and probably we appoint 4 teachers, we divide the money.
You cannot do that. If you do it, you do it at your own risk.
So if that is the case, Your Lordship, we cannot do it. Yes, we cannot do it. But there was an inter-understanding of the teachers.
That is for them. Do you have an agreement?
That I have to take the instruction whether there was an agreement.
If this be the thing, then definitely this court will not approve those kind of arrangements.
No, we have to see whether there was an internal.
Salary for 3% divided by 5%, 10%, at least.
But that is the
that
practice
will not
what is
be
going
approved
on
by this court.
in the district.
See, internally, if you have any agreement to do that, then this writ court will not decide it. You will get it decided somewhere else.
Yes.
We will just confine to the basic claim of the petitioner, whether petitioner is entitled to salary or not. If he is entitled, the court will pass an order, release said salary, and if it is found is not entitled, we will dismiss the writ petition.
No, but now it is the petitioner who has to prove that he is teaching in a sanctioned post.
You see, it's natural. See, it is onus is always on that. By provision of law, whoever comes to court, the burden is on him to prove it.
Yes.
So that definitely Mr. Devnath will have to prove it beyond reasonable doubt. Yeah. Now he says that he is not getting salary.
He is not getting salary.
Now he is getting salary. He says.
Your Lordship, in this case, my learned friend has submitted, I am the Hindi teacher, totally false. Totally false as per record here, Your Lordship.
Okay, we'll see.
And another aspect of the matter, Your Lordship, when I came before this court, prior to that, I got my salary in my account. When I approached before this court, prior to this, Your Lordship, the government has deposited the salary in my bank account.
Then why you have to come?
So after this, when they are not paying to me, then I approached before this
They have
court.
stopped paying after you filed the writ petition.
No.
No, that
Yes.
is not the case.
That is what is.
No, Your Lordship, no,
But that is
before
not the
that.
case.
Before that. So prior to this, they had given me the bank account, and after that, when they stopped to make payment, then I approached before this court. And thereafter, it was pending. By this time, government has
Now that
inquired
order
the-
which Mr. Dey has referred in the earlier round of writ petition, is it relatable to you?
No.
You have no.
I am not the party also there.
So the private respondent is a stranger to you.
He's stranger to me.
You made him party or he got
No,
imputed?
he came and make the party. So after
When
this,
I
after
file contempt on the submission made by the managing committee, because another writ petition is pending connecting to the same post lordship, then I file implement the contempt of.
That is to be determined. If see, one thing is that if any sort of evidence is projected before the court that both of you have some legitimate claim about the post,
Yes.
then definitely
Based on the
it is either the government or the managing committee will be answerable.
Based on the records.
We will not allow, you see, like this kind of things. That is for sure. Either of you will go.
That is why lordship, because what my friend says, because in a school lordship, that school was established in 2000 lordship. Then from 2000 till 2000 under the management lordship, because entirely the salary with regard to the teachers were paid by the management. Then in the year 2010 lordship, almost 100 teachers, 100 schools under West Garo Hills were taken over by the government.
It's a LP school.
Yeah, UP lordship.
UP school.
Under
Taken over means what?
Under SSA lordship.
This is brought under
SSA.
brought under.
Sorry.
So the school was not taken
Yes,
over.
no. Brought under SSA. Then there is an order. Common order was issued to all 100 schools. Same order saying that you appoint such teachers. And after that, contract agreement was signed. They have given a specific direction to select 3 teachers. Managing committee among the 6 or 7 teachers, they have selected 3. Yes, you are the SS supported teachers. Then contract agreement was signed. Then as per the direction, then they were sent for induction training. Then they were, some 3 teachers were SS supported.
Contract agreement with whom? With the
government, managing committee and the petitioner, tripartite agreement, Lordship. Then Lordship, then one set of teachers are SMC appointed teachers and one set of teachers are SSA teachers, called contract teachers.
So SMC teachers are not coming here. We are not.
My contention is that he was SMC teachers.
That is your contention. But then otherwise under SSA, SMC teachers is not coming, isn't it? SMC teachers definitely will not come.
That is why the charts which the government has given, because they have maintained the charts who are the SSA and who are the SMC supported teachers, and what are the prerequisite conditions or the documents in order to claim that I am a SS supported teachers. What are the documents need to be established to claim for the post? Because school was not taken today. School was taken.
You saw the government agreement. You said that SSA teachers had to execute agreement. So once you produce this agreement finish.
That government also saying that 3 documents are need to establish. One is agreement, one is proof of induction training, and one is that UDICE, because they maintain the data.
Now say supposing if a person has only UDICE, the other 2 documents are not there then? Out of these 3 documents, 3 proof.
They have.
If a person has only one, and other 2 are not there, then what happens?
Then it will be regarded as SMC teachers.
So it means to claim your proof that you are SSA teacher, you must have 3 sets of proof.
Yes.
Somebody having agreement, but then has no name in what is you say that portal UDAI or whatever it is, then he will not be regarded as SSA teacher. He holds an agreement.
Yes.
That is the argument. Not very appealing. At least to this court. I do not know. If you say, the basic norm says that if you are inducted as SSA teacher, then you will have to enter into an agreement. That should be the only set of this evidence.
Then
subsequently, if your name is uploaded in some portal and all those things, this will be on the basis of this only.
Yes, then they were sent for induction training. That certificate.
Induction training will confirm that this agreement has been acted upon.
Yes, Lordship.
You and me, we can enter into one agreement.
Yes.
But then we may not act upon.
Yes, Lordship.
But then once you go and join training, it means agreement is acted upon.
Yes.
It's okay. But then just because somebody's name is uploaded, will never prove that he becomes SSA teacher.
But the government has given 3 criteria.
That is as per their wisdom. We may not accept these 3 criteria.
That has to be heard.
No, we'll be hearing it
based
at
on the
length.
reports, Lordship.
But then these are things very unfortunate. I do not know how it happens.
Normally, what has happened? If I can brief this honorable court.
A few days back, I came across one case where there are 2 schools in existing by the same name.
Yes.
Now,
I'm also
you are also there.
Yes.
So just imagine the situation where we are having.
Now,
and especially this education, where a huge amount of money is spent.
Now, what happened, Your Lordship, if I can brief, in a school, there are 7 teachers or 5 teachers. They are all appointed by the managing committee. Now, subsequently, SSA came into existence. They take over the school. And then they say that only 3 teachers' salary will be paid by the SSA. Now, what happened? There was an understanding. Either there is a written understanding or there is an oral understanding. There was an understanding among the teachers that, okay, fine, this money of 50,000 has come to the school account, we'll distribute it. Subsequently, what happened? The money are transferred directly, e-transfer, and it goes to the account of Mr. A or Mr. B. Now, Mr. A, when he saw that, the money has gone to the account of Mr. A, he doesn't want to divide the money. There the crack of the issue is.
I can understand that. But then only if a person has received it on account of himself being a teacher under SSA, the legal claim is with him. So far as the understanding of the managing committee is concerned, that becomes a secondary.
Secondary. Correct. Only
Earlier, the disbursement was used to be through managing committee, where managing committee used to hold the bulk of the money and distribute it according to the understanding.
Because
Now,
of the e-transfer.
it is going to the individual account, and the individuals are not ready to part it with anyone.
Yes.
But then they have a legitimate legal right. They, what right others will have?
Others will have. Correct. There is no
So you are
dispute
getting
on
money coming to your account.
No, Lordship. That is till 2018, Lordship. March
August.
2018.
August, you got it.
Yes, Lordship. I was getting Lordship. That records will speak. There were some area salary also for the year 2016. I got it. Until March 18, then April, May, June, July and August. 5th month salary. Then from the problem starts from there, Lordship.
From September, you are not getting. That is what the earlier order, which
Yes,
Mr.
Lordship.
Day had referred.
Yes, 5 months directly went to his account.
So now he is receiving.
No, he is also not receiving from September till just.
No, but then
recently,
if it is going to the individual account, then managing committee is not answerable. They are not getting money. Then who will pay?
That is why records now, the government affidavit also clear, the other documents also very clear. So what are the?
Nothing is clear to me. It may be clear to you.
that
But
is
then this court has
That is why you
not
need
got any
elaborate-
clear picture.
elaborate hearing, Lordship.
Now we'll have to grill Mr. Abraham. You have to say how it is.
Yes,
See, ball has come back to your court now.
No, as per in my report.
You see, just tell us one thing before you come to these things. 3 teachers under SSA.
Yes, Your Lordship.
You are liable to disburse salary in respect of the 3 teachers.
Yes, Lordship.
Now you are disbursing salary to which 3?
To the managing committee. The managing committee will.
It has to go to the individual account.
Then the managing committee will subsequently transfer to the individual account.
But then just now managing committee said it is going to the individual account.
No, because that's a process, because now it will. It is the. If I'm not fully prepared. It will the money will be transferred to the managing committee. Managing committee will subsequently
Managing committee is saying it is going to directly to the account.
Just listen.
So it means Mr. Day is incorrect. No, we'll record your submission. There is no problem in it. But then the correctness of submission, you see, that is one thing. Are you sure that you have the instruction to say that money is going to the managing committee?
That process I have, but I am not in a position to assist the court.
No, you have to. See, like once you do a hearing in this court, to see where things will be digged up to, you do not know.
Then that
will be just like CBI or any other investigation agency will go and investigate everything.
That procedure, how the money has been transferred. If I will be given another, let this matter come up on Monday, I can assist the court in probably how the money has been transferred.
We will be giving time. Mr. Devnath has already sorted it, but then we just wanted to know what is the matter about and why is it pending for so long. 2019 matter. If it is salary matter, how concerned people they are surviving without salary.
Yes, Lordship. How the money has been transferred, that if I may be given to.
So now Mr. Devnath is not getting salary. Mr. Sheikh is not getting salary. Where the money is going?
Your Lordship, after the inquiry, now at present, current salary it is giving to me.
My Lord, if I can clarify. My Lord, if I can clarify. As per the order of Justice Mir, Mr. Sheikh got the salary.
It's up to certain period.
After a certain period.
Yes, after rules. So what you say,
Yes.
that is you pointed out just.
Yes.
That thereafter disbursement will be according to the rules.
Yes.
Meaning thereby whoever is holding the post legally.
Yes. Then what happened, my Lord? As per the order, Mr. Sheikh got a salary. Then there was an order of Justice San. Then again, that create a confusion.
That is no. See, this is not a clear-cut direction.
I just
If it
correct,
is so,
Lordship.
if it is so, means that is where the thing comes.
I got the salary before the order was passed by Justice Mir, Lordship. When my salary stopped, then only I came to the. It is not that after the order was passed by Justice Mir, I got the salary, Lordship.
As per the instruction, my Lord, I am submitting. Subject to correction, my Lord, but that was the instruction that Mr. Sheikh got the salary, then they approached this honorable court, then their confusion created, my Lord. And we have written to the DMC. DMC has not replied to us till date. And that is on my affidavit. On oath we have stated.
I do not know. So stand by the parties are very evasive. Nobody has taken a definite stand. At least what I could gather from submission of you all, these are all evasive standards. Just, you see, shifting the burden from one person to another.
That is why we have to
But
go
then
by the
who
process.
is entitled, nobody is saying. It is not coming. And you are the two authorities, we should say. They are the beneficiaries.
Now, sixth name
They will
has
have
been,
a clash.
if your lordship, sixth name has been referred to the government, which three they have picked up for the SSA, it is for the government to take a stand. The managing committee has no role because we have six teachers.
That is one aspect of the matter, so far as
Yes.
appointment is concerned. But
Yes.
so far as discharge of duty is concerned, that is for you. You can say it.
No, I can also say, my lord.
You
but
can
it-
always give a details to the court.
Yes.
That in your school there are how many SSA teachers and how many SMC teachers.
Yes.
If you give us a list, we can determine it from there.
If required, we'll file an additional affidavit to clarify that point.
Required, the court will ask for that definitely.
Yes.
It's a government
That is
affidavit.
very pertinent also, my lord. But
The government also will do the same thing.
Is there, Lordship? Is there? Details is there, Lordship. Till 2018, Lordship.
It is supporting you.
Obviously, Lordship.
That is why you
Even
are
the
harping.
petitioner, even the
That
petitioner.
is right from the beginning. You are harping on government affidavit.
Lordship,
government
even the petitioner has filed some document. That case, that also reason that also supporting me, Lordship. Same document the petitioner has annexed.
No, we will be definitely giving weightage to the government affidavit because there is the law says there is always a genuinity.
Okay, today only. No?
No, it is not that petitioner also have annexed some documents, Lordship. So I am relying that document also, Lordship. That the details of the teachers. Same documents he has been relied.
As per the SS norms, there are only 3 teachers. That is, one teacher for language, one teacher for science and maths, and one teacher for social studies. Then they can also appoint 4 teachers. 4 teachers that has to be paid by.
Who are the one teacher? By name you just say.
Then that will be
Subject wise, you see, it will not be. We cannot determine. You say salary will not go to the account of science teacher. You will go to the person who is named as science teacher.
I'll find out, yes.
Because you have to find out. These are the crux of the issue. You see, until and unless you come out with those things, this court will not be able to decide it.
I'll do that. I think.
And just because some court passes some order and all, it is not that you see, like if it is not correct, it should be implemented. You should always come and seek modification or alteration of those orders. That option is always there.
Maybe there may be 4 teachers, 5 teachers, 6 teachers, but that has to be paid. That has to be paid at the.
That is a difference. So then, in such a case, those teachers will not have any agreement with this thing.
Yes.
But that
with the government, as SSA teacher.
No, but if there's any agreement, that agreement is null and void, Your Lordship. If there's any agreement, that agreement is null and void. We have to pay it only to those 3.
No. How can a person enter into agreement? You will be answerable then.
Whatever.
How can you enter with any number of teachers if limit is 3 teachers?
Yes, Your Lordship.
So your officer will be answerable then.
But
if you find that there exists more agreements, then your officer will be answerable.
If government is the part, if government is the party, it is an agreement. Government will be answerable.
And the private respondent.
100%.
They have gone beyond the institute.
That agreement, we never enter into an agreement. We specifically.
Then the question of saying that any document will be nullity doesn't come. The basic understanding is that.
But that agreement, Your Lordship, it never entered between the state respondent. It has been entered between the managing committee and the concerned teachers, you see.
That is so far as SMC teachers are concerned.
So that agreement should be null and void. Because if the government.
You have a format of this agreement. Do you have anybody for format of that SSA teachers agreement?
Yes, Lordship. There is a common agreement executed to all the teachers, Lordship.
Who are the parties in these things? Government also is a party. Managing committee and the teacher.
And the teachers, Lordship.
Tripartite.
Tripartite.
Now,
but that agreement.
If you are the signatory, you being public authority, you will be answerable.
With that agreement, there's no system of sharing the salaries, Your Lordship.
That is no, you are not answerable for that. We are not seeking any answer on that aspect. What we will be requiring is that if you are at all disbursing salary for 3 teachers, then who are those 3 teachers? You will give us the name, and on that basis of the name we will decide.
I'll do that.
If by executing an agreement by the 3 parties or 4 parties, and government is a part of it, then it is they who has encouraged this wrong thing.
Definitely, government will be answerable if they execute any agreement beyond that three teachers.
Because the statute provide 3 teachers.
They will be answerable.
Let them satisfy with the documented evidence. Then that allegation, if we enter, then we take the responsibility. But without any evidence proof, we can just shift the burden to blame on the government.
Nobody has blamed you. Has anyone blamed you?
Not blaming, but see that.
The simple thing is that if there exists any agreement beyond the 3, then definitely you will become answerable. So till now that situation has not come.
No, yes, true.
So there is basically no reason for your reaction at this stage. Then you say, give us the name, then give us the 3 names with whom you have accused these things. You should, it is at the hearing stage, you should be ready with those names. You have those names.
Page 2. Page 2 of the government.
Page 2 of government or affidavit?
Does the government affidavit answer?
Is it respondent number 3?
3.
Government is respondent number 3. Then page 2, where is that?
Page 2, Lordship.
Yes.
Start from that first.
It may be stated herein that when a school is brought under SSA, what is the agreement?
No name is.
No name has been mentioned.
Name is there, Lordship.
No.
Down name.
No, this is on the affidavit.
Lordship, once the teachers are appointed, a contract papers are signed between the so and so and 2 witnesses.
Where it is? Which paragraph?
Same paragraph.
Same paragraph, Lordship. Lordship.
Once teachers are appointed, contract. This is a general statement.
Now names will be there.
Signed
Lordship.
between the.
Names will be page 3, Lordship.
So, who are the person who signed it?
Yes.
We want a specific name.
Page
Where is
3,
it?
Lordship.
Huh?
Page 3, Lordship.
Where it is?
It may be stated. It may be further stated herein that the UDISE data available. If my lord may kindly come to page 3 of the government affidavit.
Yes, I'm reading.
Data available with the Office of the State Project Director (SSA), submitted by the District SSA Office of West Garo Hills, which affect from 2012 to 2013 to 2017 to 2018, shows that the petitioner is appointed as an additional teacher by the School Managing Committee, and so why referred as School Managing Committee teachers, whereas name of so and so, so and so, so and so in the UDISE data list appears.
This speaks about the data. We are talking about the agreement.
No, agreement.
Agreement I have enclosed in my.
So far as you are concerned.
Yes.
So we want what we want. We want 3 names.
3 names. Yes.
3 names. The government should say that.
Yes.
You give us the details of those 3 names.
Yes, Lord.
With whom you have agreement. Not on that UDISE databases. With whom you have agreement in respect of the school concerned.
Yes.
If furnish it, we can solve the matter.
Yes, Lord.
This should be solved for once. No, you see, there is no other option. In fact, the government affidavit should be specific. Why you are basing your affidavit on the basis of some data available? That data anyone can enter. Whoever sits in that table can enter.
I'll take a detailed instruction, Your Lordship.
At the time when the school was brought under SSA.
You said agreement and the training. What is
induction training?
Induction training.
Because
you must have records. Government, you being government, you must have record. You check your record and just see who is there. Give their name.
I'll do that. Yeah.
Others will be thrown out from SSA, not from SMC. That is what we will do.
This is very interesting. If my lord may kindly come to the private respondent affidavit, annexure 1.
He is
respondent number
10.
Respondent number 10.
Wait. You are referring to annexure?
Annexure R1, page 8, Your Lordship.
Just a minute. What is the page number of that?
Page 8.
R1.
R1.
Yes.
Let me kindly see from District Mission Coordinator.
Yes.
SSA West Garo Hills, Tura.
Yes.
To so and so.
Yes.
Of Haldiaganj, District West Garo Hills. Subject contract appointment.
Yes.
My lord, may kindly see. The undersigned is pleased to inform you that the SMC.
It is for 59 days only.
Is for 59 days. Yes. Now, my lord, may kindly see you will be entitled to terms and condition. Number 1.
Salary 3,000 rupees.
3,000 rupees. Yeah. This is a contract agreement which has been made.
After 15 days, it will lose its value.
It will lose if it is not extended.
Yes.
When they were sent for induction training. Page 10.
This required a proper hearing.
Definitely, we'll be having problems.
On the meantime, we'll exchange our pleadings also, so that we'll be in a better position to.
Already it is there. All the affidavits are
Some
there.
of the affidavit which has not been given supplied to us.
In between yourself.
In between ourselves. So we'll
Do not make our file more bulky. You see, it is already.
No, our. We have to make our file bulk.
That will be internal arrangement between us.
So once we get the affidavit of each other, then we will know what is the stand of the government and what is the stand of the private respondent.
Government affidavit is already there. It's enough for knowing their stand.
Because,
but then they are playing hide and seek game. You see, they have not named anyone. Nothing. And what is the norm of SSA? Can it be this thing agreement for 15 days or not?
I don't think so. In SSA, such thing provides.
The scheme is with what, Mr. Abraham? Generally,
I am not.
The scheme is for indefinite period, isn't it?
Yes. There is no contract.
Extending from time to time.
So once a person is there, means person is permanent.
Yes. Permanent.
So this 59 days will not come here. Yes. So you were gone after 59 days.
Lordship, I got, and that headmaster and one more, that science teacher.
No, you are gone after 59 days. Once 59 days is over, then you are no more there.
No, my lord, similar contract was entered throughout the state lordship. Same for the same.
So then all will go after 59 days.
Still, my lord.
See, two wrongs will not make a thing right.
True, that's true.
So you just to support your wrong, if you bring instances of other wrong, that will not justify your wrong.
Now at this stage, after serving 10 years in the SS 8 years, then can the private?
You always know your service condition once you accept it. If 15 days is written, you are a teacher, you cannot say that I am illiterate, I cannot read.
That is true, lordship.
Yes, Mr. Devnath.
Let me.
You are the petitioner, and you are mute here. You are not speaking, others are speaking.
So, Your Lordship, 2 weeks, Your Lordship.
2 weeks. But then, if there is no inquiry, then what is the purpose? What purpose these 2 weeks will serve?
Your Lordship, inquiry is there as per this whatsoever letter I
we'll
got.
just see.
So,
if there is an inquiry, government can produce. Why we
so
should wait for the RTI?
Mr. Abraham says there is no inquiry. It is
but,
there is
but
only
the
a
letter
report.
whatsoever I produced, Your Lordship, it is there. Inquiry report is there.
So we'll see to it. We'll see to it. If you make a false statement, you will be heavily penalized.
And in this matter, Your Lordship, that when this inquiry is supposed to be conducted by the government, then private respondent came before this court to stay the matters, not to inquire the matters. And before this court, and after this inquiry took place, Your Lordship. So it is inquiry.
I have not followed.
Your Lordship, when this matter was going on, by this time.
This writ petition.
Yes, Your Lordship. In the meantime, there was order from the government to inquire about the position of the teachers. So private respondent come with the petition before this.
Position of the teachers in general or only with regard to
only these two. So after this whatsoever.
Where is that order?
So Your Lordship, after that whatsoever, this private.
Where is that order ordering inquiry?
So, inquiry report is not there, Your Lordship.
I am asking the order and asking for inquiry. Conducting.
This is in miscellaneous application given. It is I am not getting here, but private respondent filed the petition for stay, and I oppose. And after that.
Stay of that inquiry.
Yes.
Why?
So after that, Your Lordship, after that court allowed to go for inquiry.
So and stay was rejected.
Yes.
Government should have taken a stand.
Where is the order by the court with regard to that thing, rejection of stay?
This
with regard to inquiry?
This is in this court, Your Lordship. I am not getting this. I was saving here, but I am not getting at the moment. But it is there in this court, in the court record.
Which way this court will know it is there?
So
if it is a court order, it should be there. It passed in which miscase?
This case, Your Lordship, this one. This makes inquiries.
If you make a submission basing on records,
Yes,
please make
based on
sure
records.
that you are ready with it. Otherwise, court will take it as a false submission. And you know the consequences of making false submission in the court.
It is not false, it is correct submission.
Say so much of development, you are saying it. Is it correct, Mr. Sheikh?
Yes, Lordship.
There are some.
There is so moto inquiry attempted to be conducted by the. There is no order from
You
the
sought a
court.
stay. You
When
sought,
the matter was
MC
pending.
number 190 of 2022, Your Lordship.
you have the order. MC number 190.
190 of 2022 in 56 of 2019.
And this, your prayer for stay was rejected. So you are looking for this inquiry report now.
So I am just asking for this inquiry report.
Spot inquiry with regard to salary. The official will go to the spot and see who is receiving salary. I know this one day spot inquiry will do that. So you supported the inquiry, Mr. Day.
I was in support of the inquiry, but let the inquiry took place. I don't have any
No,
objection.
Mr. Day also supported the inquiry.
Yes. Now, Your Lordship may kindly see my affidavit. We have categorically stated that let the government clarify, because there was 59 days appointment. So we don't know whom they have given the appointment, but all the teachers were teaching there. And they have not even submitted that appointment letter, extension of appointment letter. It is the state government who has to take a stand, my lord. That is
Now
my
this
understanding.
Order is dated 18th November 2022. An inquiry has been conducted and the report? You say there is no inquiry.
No. As per the record available, the petitioner had written a letter to the department.
This order was not brought to your knowledge. You did not know that.
This
The
was
government is not aware of this order.
No.
So what about this thing that one letter dated 1/11/2022 by which government has instituted one inquiry, spot inquiry?
I received.
You have a letter of dated 1/11/2022.
The 22 letter I don't have. I got the report from.
So many things are matter.
7th March 2023. Then they have given the data. I mean, they have given the report of 19th May 2019. That was on the basis of the letter.
No. You see, it seems there is a letter from government dated 1/11/2022, pursuant to which was one spot inquiry was supposed to be held. Now that is what Mr. Devnath is referring to.
That I will have to take. I may be given some time. I'll take it for instruction. That day this letter was forwarded to me by the.
Please. We had a lot of discussion today. You know now what is needed. Please be ready with all those things. We do not want to linger these things. These are small issues. Yes, Mr. Devnath, when do you are likely to get this?
Your Lordship, let me at least 2 weeks time so that I can get it.
Make sure it is not adjourned unnecessarily. We should
Government
finish
has
it.
to provide the report, and the matter gets solved, Your Lordship.
Or it may come after 3 weeks. By this time, if I get this, and I will file the affidavit, including this inquiry
I
report.
feel, my lord, if the government has already conducted an inquiry, the report will be definitely with the
Mr.
government.
Everyone can also
Yeah.
inquire. Anyway, since he has filed an RTI application,
Your Lordship,
that
here
is what the problem is.
My lord, may kindly see the miscase 190, where Mr. Sheikh has opposed that inquiry.
Yes.
And
that's
that miscase was rejected.
Yes.
Definitely there was an inquiry conducted. If something else has not been managed.
That is what. So, anyway, heard the matter at some length. Mr. R. Devnath, Learned Counsel, opinion for the petitioner, submits that petitioner has filed an RTI application seeking furnishing of a report, an inquiry report, which was conducted by the state authorities in relation to the what is it, which was no, before that inquiry. This is, did you say? Spot inquiry. Just make it spot inquiry report, which was supposed to be conducted in connection with payment of salaries of the teachers of Singimari Girls SSA Upper Primary School. The Land Council submits that the report would be relevant for the purpose of deciding the controversy involved in this matter. Purpose of deciding the controversy involved in this matter. Considered the submission. Stop. The Learned Council, the Learned Council appearing with the respondents have no objection. To the prayer made by Learned Council petitioner. The matter after full stop gives the matter stands adjourned. This is after
3 weeks.
3 weeks.
3 weeks.
3 weeks. All right. So both of you have no problem remaining without salary.
In the meantime, Lordship, that
List is after 3 weeks to enable Mr. Devnath to place the inquiry report
Lordship,
on record.
in the meantime, what my Lordship has said that regarding the contract as well as that induction training for the 3 teachers, Lordship, either the government or the management, because the documents is lying with the management also, they can also.
They can definitely that if you required, but then you see right now what Mr. Dey has pointed out, your appointment was for 59 days.
An inquiry
So
report.
whether you have gone for training or non-training, it becomes irrelevant in view of that 59 days. It is presumed when 59 days is gone, your service is gone.
My Lord wants that I am appointed under the scheme. Then I can continue till the scheme exists.
You have accepted the thing.
Yes, and contractual law is very
Once we accept, until and unless you can show that once you are appointed under SSA, that you have the right to continue for indefinite period of time, or so long you attain the age of retirement.
I was getting the salary till 18 Lordship.
That is okay. That is all
It will be very
past.
premature for us.
Only thing is that,
My lord.
59 days, Mr. 59 days, once you sign it, and until and unless there is a law contrary to that 59 days, then estoppel will come.
Yes.
If law is there, estoppel may not come. Then you have to show that law.
What I understand, my lord, since there was an inquiry, and if there is an inquiry report that RTI or the government will provide, my lord, then it will be very clear, my lord, who has been inducted as an SSA teacher out of these two, my lord. And they will have indefinite right, irrespective how they was appointed. That is my understanding, my lord. I am open to correct it, my lord.
That is all right, but then we will see what are the terms and conditions of appointment and all those things. Okay, and in fact, how many teachers have been appointed under SSA? That also government, let the government lead.
Yes.
Because we have made it clear that we want the three names. If there are 4 names, then they will have to explain how the 4 names.
Names, yes, my lord.
Would you read the order again? Just see.
for inquiry. Filed a RTI application. The state authority. And yes, controversy in this matter. Stop. And praise for grant of some time. And accordingly praise for grant of some time. Yes. Then come to next. Then what is the next line? Yes, before this court. That will do, I think. Mr. Abraham, a lot of responsibility.
I'll do that.
Be fair and play one impartial role.
I'll do that, Your Lordship.
It's a state. The entire, you see, the principle of justice and fair play is dependent on state.
I'll do that, Your Lordship.
Yes, after 3 weeks.
Item number 14.
Please, Lordship.
Yes.
This order, Your Lordship, as per the order dated 23/5/2023, the respondent make a submission that the entire matter is under consideration. That this is the order. Actually, on the
Here,
last
my lord,
occasion.
what happened? They are seeking amendments for a direction to the district council to release the pay salary as per the 5th pay commission. Now, district council, the previous executive committee, in a very harsh way, my lord, they have said that the pay slip may be made in the 5th pay commission as per the recommendation of the 5th pay commission. But similar situated case was there, my lord. Another single judge has said that yes, in municipality, my lord, in the case of municipality association, they say that 5th pay commission is applicable to the Shillong municipal employees also. But that order was challenged by the state government before the division bench, and division bench said that autonomous body, 5th pay commission recommendation is not binding on the autonomous body.
Until unless they decide to.
Until unless they decide. So we will take a stand, my lord. And if the division bench order is there, my lord, and that is not under challenge by the association, that is binding on before this honorable court, my lord. And now, my lord, can there be a direction which will direct when the matter is to be decided by the district council?
If your submission is that you have not accepted the recommendation of the 5th pay commission.
No.
Have you accepted?
No, my lord. We have said at a particular point, we have said that to draw the salary as per the recommendation of the 5th pay commission. That was not done as per the studies. But as per the division bench order, my lord, we have to have our own body to assess.
Where is the division bench order?
Division bench order is division bench order passed in writ appeal number 12 of 2021, dated 28/3/2022. This is an order.
You have a copy?
I have a copy. But we have not enclosed this order because during the pendency of this case, only this order was passed.
12 of 2020.
Some parts are not legible because of the seal appearing in the middle.
Yes, my lord. It was.
Here it's a case, definitely. But then the only direction is that you say like here the state is the employer because municipality the state is employing them.
Yes.
I think for district council it's not. State has no role so far
The
as
state
this
has no
goes.
role.
So that part also will not be applicable to you. So you are total independent, totally independent.
We are totally independent. Now it is.
It
the
is in your
district council-
wisdom whether to accept or not to accept.
Not to accept. Now your lordship may kindly see the annexure 1 of the writ petition, page 16.
Anyway, before that thing, what Mr. P.T. Sangma
Lordship,
wanted to
this
say.
is what
Yes.
I'm trying to, because here the case is the GHD themselves, they have approved this PPay commission, which my learned friend is right now, he's referring.
Was it implemented?
They have approved to implement this PPay commission. So it is not the petitioner who is asking, who is coming before this court to seeking direction for implementation of the PPay commission. It is the GHDC who have passed a resolution.
If they have implemented,
they are not implementing. They approve. They said, may I read the?
If I
they-
can take
may
my
just
lord-
one second. Whether this approval was acted upon.
No.
That's why they are not acted upon,
Let me just,
and they have not acted upon, and then after the passing of this resolution,
let us come to the points of law, question of law.
Lordship.
Now, if a decision stands approved, can it be reversed or changed?
No, Lordship, they have.
What the law says, the district council, can they do it?
No,
is it not that the extension of pay is a matter of policy?
But till now they have neither changed this. There is no resolution or modification as of now by the district
So
council.
you want to say that their
They are just
decision still is.
Lordship, because they have approved this one. Is very clear. Is that this council is pleased to approve the enclosure Meghalaya government resolution on the recommendation of PPay Commission on Wife so and so dated Shillong 28 November 2000. It's making it applicable for implementation of PPay Meghalaya Pay Commission in JHTC with effect from 1st January 2017. This is their order.
This is the resolution.
Resolution.
And any notification thereafter?
After there is no notification, but there is notification that they're saying that since there was no fund, they said that this will be implemented later on, but only said since there is no fund, they will pay.
No, but then once they say it will be implemented with effect from such and such day,
yes,
it has been mentioned.
Lordship.
And unless there is any other fresh sort of resolution contrary to it,
Lordship,
they are bound to implement it.
They are bound to implement it, Lordship. And there is no condition also where they had never mentioned that when there is no such fund is shortage, then we will there in this approval they have not make any condition.
And we will go for disposal today. Are you ready for disposal today?
Lordship, actually this is the pending. Actually, my only stand is this. Since it is they have improved, they have approved. They have approved. Even in their affidavit, they said they never said that they will never implement this one order. They only says that
to implement or not to implement is up to them. But then once they decide that they will implement.
Lordship, that is my case. But they have stated that they have approved.
Wait. Especially with effect from certain date, then not to do it also calls for some explanation. They will have to explain it why they are not.
Lordship.
Now you say that there stands already a resolution, and the resolution is very much clear about the date of implementation also.
Lordship.
And subsequent to that, there is no other
notification.
Yes, contrary
to this.
Now it is now incumbent upon the district council to implement it. So Mr. Dev will have to reply that.
Yeah, they have to. And they have even in the order, the council has make a clear statement, Lordship, that they will implement it. They said entire matter is under consideration for implementation of the pay commission.
Under consideration is different thing.
Lordship, but I'm just saying because it was reflected in the order, he has make a submission to the court. Making submission to the court, which is under this also is reflected, means they cannot make simply. That means he is presently on behalf of the JHD. That means on the last occasion he just wanted to clear just to get the instruction on this matter. So that means we were thinking that means it is under process. So now is they have to reply to that. Why?
Few days back, there were some cases by some sets of employees saying that they were not getting salary.
Yes,
even the salary which they were entitled.
Till now,
you think they will implement 5th pay commission?
No.
The salary which was existing prior to the implementation of the 5th pay commission also, the district council was unable to pay it.
No, in the affidavit they said because...
No, of course, this is not a defense. You see, I'm not countering you. I'm just informing you. So this is the situation.
The situation, they said that in their affidavit, they make a plea that they are not implement this PPA commission and the approval order because that time they make a stand on COVID.
This resolution was notified.
No.
Was it notified?
No.
After the district council adopted the resolution, was it notified?
Was not notified. They have notified.
Notified. Where is the notification?
This notification is there, but it's not there, Lordship. But then I just presume it because
once notification comes, there you can say yes. The decision was, decision is to be implemented. That is what you see. That will project their wholehearted decision. You see, wholehearted. Yes, their wholehearted decision to implement a thing. But then say supposing if they take some resolution and that they do not notify it, that means what it would project that there remains some sort of hesitation on the part of the authorities to implement it. Maybe some reason. Today you may force them to implement it, but then if they are unable to pay it, what benefit you get?
To that effect, Lordship, actually,
anyway, has it been notified? Just say
it. That I just need to get his instruction. Only on that.
Mr. De, what you will say about the resolution? If you take a resolution, why you are not implementing it then?
No, the resolution was there. As I have said, very hurriedly a notification resolution was taken, which has not been notified yet. Resolution, there may be hundreds of resolution, my lord, but we may execute only 15 resolution. That is on us. Now, second thing, my lord, technically, if you go technically, whether the writ petition is maintainable at this point of time. It has not been notified. Second thing, there are 4 employees who has approached this honorable court to get a direction to implement or to execute that resolution. Now, out of these 4 writ petitioner or 5 writ petitioner,
That's already been deal.
When I'm submitting,
We'll come back to you. Don't worry.
2 of them they have withdrawn. They have withdrawn because they are no longer the employee of the district council. Now, my lord may kindly see the affidavit. Who has filed the affidavit in the writ petition? This is after the affidavit was filed. And we pointed out.
Fleming v. Marak.
Yes, Fleming v. Marak. And he withdrew himself.
No, it is not withdraw. He retired. He taken a voluntary retirement.
But then his name has been struck off. Name has been struck off.
He has been struck out, but that is after filing of the repetition.
It's okay, then you have to correct it.
He has to correct this.
You have to correct it.
A fresh affidavit
That
has
is
to
the
be
law.
sworn.
Now, if there is any false statement here, who will take the responsibility?
No, because that in that order.
Second thing.
In the
Let me
order
finish my
also
lord.
it is
This was not pointed out by you, Mr. Day, earlier.
Yes, no.
We have pointed out.
We have already passed an
We have
order in
pointed
the
out
order
that
dated
last order.
23/5/2023.
If my
That
friend-
is already reflected.
If my friends
So why you are hurrying up?
Lordship.
Don't
Stop
get
asking,
agitated.
then I
Don't
can-
get
I can
agitated. You'll be getting
submit,
time.
my lord.
Yes.
My lord, here we have pointed out, but since we have also, the matter was also been decided by the executive committee, this was, again, the executive committee is rethinking over it as per the order of the division bench. No doubt that division bench order is totally not binding on us, but it has enlightened us that we are not bound to take the whatever.
See, you will assess your situation.
Yes.
It is not for the court to advise.
Yes. No,
Only
but-
one thing is that you are free to take your
Present
That is-
executive committee has been enlightened by that order. I have communicated the order. They are considering it. Second thing, your lordship, this writ petition, I feel, is a premature writ petition. That objection we have raised in the initial
No, no,
stage
that,
also.
what you say, that is very correct.
No,
Is that
not only in that point. Whether they have approached the authority, they have never approached the authority. There is no representation. There is no representation.
may not be a prerequisite for filing a writ
No,
petition.
may not be. But if it is not that we have approached the authority, authorities are silent on us. That representation was not made. They could have approached us. We could have sit together and take a decision on
That
this.
is okay, but then
not mandatory.
see, this may be, but then this may not be a very
may not be-
strong ground for
They-
rejecting the writ petition.
But
There is
now-
no law where we
We'll
have
come back to
lordship.
We'll come back to you, Mr.
Now,
Sit down.
can my friend, okay, that representation is not required. I bow down, my lord, on this. But can my learned friend say that this affidavit will carry any strength on this?
No, definitely that is not. But then the other objection which you have taken,
Yes.
that so long a resolution is notified,
Yes.
no right is created in favor of them.
Yes.
So they cannot come. Writ petition is premature.
Premature, as I said.
Because on the basis of anticipation, no writ can be filed.
This has not been notified.
This is-
And my lord is very much aware about the position of the district council fund. We are not even in a position to
That
pay.
is okay. That is for you to consider. This court will not go into all those things for deciding the thing.
No, why we have not notified?
Legitimacy and correctness of your decision will not be reviewed by this court.
This is not an appellate forum of the executive committee's resolutions and
Definitely,
whatever
is normally not within the court. This is beyond something the court, not court's business basically to do. Until and unless you do something
Yes.
against the enacted provision of law, or you say like.
And it is not the case of the petitioner also that district council is bound by Fifth Pay Commission recommendation and they should implement it. That is also not the case.
No, his reliance is only on one.
Only
resolution.
the resolution.
So we have to confine ourselves whether
the
this resolution will create
Any right.
an enforceable legal right or
Legal right. Yes. That my learned friend has to satisfy this honor.
Definitely. We'll be asking him. You will have to satisfy him that.
Lordship, in his entire affidavit, Lordship, just because now only just Lordship has enlightened that regarding the notification, he come to know that
Madam,
there
these are
should
all
be.
low points
He
in
have
an
never
affidavit.
raised this at the earlier stage, even in his entire affidavit, not even a single whisper on notification. He is pleading from the pocket. Means nothing is there is reflected in the
raising voice will not improve your
Lordship.
case.
That's why Lordship.
Raising
Lordship,
voice will.
I'm
will
not
not
raising
use.
my voice, but
You
naturally,
can raise voice.
I'm so
I can
sorry,
raise
Lordship.
voice. He can raise voice. So this will not solve our problem.
No, what I'm trying to submit is, Lordship, it may be correct. Just even I was not aware regarding the notification. Even he himself was not
question is
not
that-
aware.
Mr.
No, sir, if he is aware, then why he never make an attempt even in the entire affidavit? He never make a mention on this.
Now
And second,
allow him to submit.
yes, he told me not to disturb
Yes,
him.
yes. Now we are telling
I
him not
also
to
didn't disturb him because I
Now,
obliged him because
Mr.
he's
J,
my
don't
senior.
disturb. Don't disturb. Yes.
I didn't disturb
Yes,
him.
carry on, carry on. Yes.
Allow him to speak whatever he want to say. See, what I'm trying to say is that, of course,
But then do not raise your voice. Huh?
yes, no, Lordship, because I'm
This
so
court
sorry.
becomes nervous once you raise.
Because he said that notification, regarding the notification, just because now Lordship has query on me regarding the notification, then only he have studied this, saying that there is no notification, this, that. Otherwise, if he has been aware of this,
That's
the
okay,
first
whatever
instance
it is.
is
Forget
that-
it. Why,
that
how,
what
when,
I'm trying to
which
say
way.
is that he in the entire.
See, our question is on the
Yes.
question of law.
Lordship, question of
Do
law.
not go by what Mr.
Yes,
Day does.
yes. But as per the
what
ruling,
Mr. Day does will not bind us.
yes.
Okay,
But-
we will be there with law.
But
Now,
practically,
my query is that,
Yes.
please try to understand.
Yes.
Can a resolution of district council, which has not been notified, be implemented through a court?
Yes, that cannot
This
be
is one thing.
That, Your Lordship.
The second thing is that so long no notification is there, what enforceable right you have? What enforceable right is created in your favor? You please enlighten me on those points.
Yes, Lordship.
If you want, you can do it now. If you want some citation to do it, but then you have to give me some sort of.
Yes.
You say like this
Lord-
court is not very sound in law, so you have to make me understand.
Yes. Now, I will answer to that, Lordship. Regarding notification, first I have already answered that way, because first to answer all this, first I have to
What is
confirm
your
whether
answer?
there is a notification or not.
What right is created in your
Yes,
favor?
yes, that I will answer it, because now since I am not still confirmed whether there was a notification, even my learned.
So if you are not confirmed,
yes,
then
that's why I will just get a
no
clear
argument
instruction.
on assumption.
Yes,
please.
yes. That's why
If you say, I thought if you say that you are answering now, I thought you
No,
will
no,
be
I'm
giving,
not
giving
answering,
me reply
Lordship,
on
because
points
I
of
will
law.
take time only for that. Only I will just want to confirm whether there was a notify or not. Then
Now,
after
let us take one example. See, like you impose. State government, the cabinet level takes some decision, but then they do not notify it. Can you claim any right on the basis of the cabinet decision? Similar situation here. There may be a resolution
but
by the district council, but then for some reason they do not notify it, meaning thereby they are withholding it. Okay. Now, what that resolution, what right would be created in your favor, and which way get it, enforcement of that in a writ court? These are the questions, query which you have to clarify by citing laws.
Lordship.
Because I do not know law, so you have to clarify.
But as of course, regarding the notification, that I will take them. But the other thing, like, but there is no another resolution or modification.
That is okay. That is
or
this
any
court was
corrigendum
taken. See,
to that effect.
this court was
That is not
initially under impression that resolution, but then suddenly that notification part came. You see, resolution becomes public once it is notified. Government may take many decisions until and unless there is a gazette notification. You cannot seek implementation of that.
That's
the similar kind of things. What is district council? District council is a government within government. It's a mini government. So this business of their function or business is more or less similar to, akin to the government functions. So that is what.
I will seek the instruction on this. I will just whether they have notified or not. Then accordingly, if there is no notification, then I will.
Then
try.
what for you give me this order passed by another coordinator?
No, this order I just want to reply, because that again they said that is under consideration. That's why I just wanted to inform
Yes,
this court.
under consideration. He still says it under consideration.
I'm saying that
He has not said that he has revoked it.
Yes.
Mr. Day tomorrow may come up with say that we are implementing it. So you should may become very happy. Now the thing is that the point which he has pointed out, the affidavit part, if somebody is no longer part of a writ petition, then you have to correct it.
On that day on the same order only he was there. He never raised this one, because
now he is raising and it's a correct thing.
Yes.
Okay.
And in the order
so
is
you have
reflected.
to correct it. It is not that you have to you draw writ petition, all those things. You have to correct it, and how you do it, I am not to advise you. You do it. Okay, but then that has to be corrected. So his name has been removed from the area of
Yes.
thing.
Petition number 1 and 2.
Yes,
That,
area of parties. That things.
That's
Yes.
yes. We will correct at the same time.
During the course of the hearing of the matter, Mr. Day, learned counsel, appearing for the GHADC, points out that who was this thing? Number 2 or
Fleming.
number 1?
Number 1, my lord. Fleming was number 1, my lord.
The name of petitioner number 1
You have taken voluntary
has been
retirement.
struck off. It's okay. Struck off from the area of parties by order dated 23/5/2023. However, give a comma, after give a guess. However, the affidavit attached to the writ petition still carries oath of affirmation by the petitioner number 1.
Number 2, so Lordship.
No, but then affidavit is by only one.
Yes, only one. Lordship.
You have to correct that.
Yes.
Give a full stop. Since name of petitioner number 1 has been struck off, the writ petition need to be supported by affirmation on oath by any other surviving petitioner.
Lordship.
Mr. P.T. Sangma, counsel for the petitioner, submits that he will take necessary steps to correct the oath of affirmation attached to the writ petition.
Lordship.
Within
2 weeks, Lordship, because I need to get the notice.
Take steps to correct the oath of affirmation attached to the writ petition within 2 weeks. Stop. Prayer allowed. List this matter after 2 weeks. This order.
I will print out one more.
You given to me also that that order.
Your copy should be retained, or
you can keep it also, no problem. But I want that my learned senior has submitted one order.
It is there already in the website of the High
But
Court.
I just need to know the case.
This is this you have to get.
You
This
get it, but I just want to know the
I will give you the
case number.
I will give him.
He'll supply you.
Lordship.
Anything more? Okay.
Much less, Lordship.